welcome. My name is Audra Heller. I see a lot of familiar faces here, and I'm super excited. This is our inaugural seminar. We're going to do it monthly, and I'm super excited to have each and every one of you here. Why are we doing this? I have helped so many clients, and I have a passion for problem solving and helping different people, and have noticed over the years that people have unanswered questions. They don't know who to trust. They've worked so hard to get in a position in their life that they haven't set themselves up, or they haven't set things up for their children. And as a past president of the Parkville Chamber, Melissa and I have got to know each other through chamber and volunteer work, and we both just started talking about this and decided, let's start a seminar. So we have been working on this for a couple of years now, and finally have brought it all together and planned it out. So again, Audra Heller with Audra Heller & Associates at Real Broker. Melissa, I would like to introduce. Melissa Moran is the CEO of Senior Helpers, Kansas City North, and we're both involved in Hillcrest Platte County as volunteering, chamber, all of that. But Melissa, I'll let you introduce yourself and tell them why you're here.
Hi guys. I'm just starting my 19th year of helping people, and I've had the privilege of helping a lot of families over the years, and the number one thing they all tell me at the end is they wish they would have started earlier with our services and of understanding all the different choices they were going to have to make along the way. So we have broken up the seminars into kind of different categories. Today we're going to talk about paperwork with our lawyers and our deed fraud information. And in August, in your bag, you each have the next date. So you don't have to worry about them today. You can look at them when you get home. But in August, we're doing the money saving tips for retirement. And in September, we're doing make your money work for you. And then in October, we're doing planning the next move. You know, all that downsizing things, what your choices are. The number of people who tell me, oh, I think mom's ready for assisted living. Oh, honey, your mom's way past assisted living. Assisted living is not what you think it is, right? Everybody thinks it's mom needs assistance. Well, there's only a few things that they cover, and what your mom needs is beyond that. In November, one of my favorites will be coming, lifestyle options in the Northland. You're going to retire, or you are retired. What do you do with your time? We have two of our vendors here, Hillcrest and Parkville Living Center. They help people find their place in retirement. Volunteering, classes, different things you can do. And then we're going to take off for the holidays. And then in January and February, we've got some webinars on technology. There's a lot of options to help your lives better as your parents and you age, but also the senior who's like, oh, I don't know how to use my phone right. So we've got those things coming up. And then, well, since I'm the presenter in February, my favorite topic is Alzheimer's and dementia. I've been teaching that since 2010, so we look forward to helping you there. So that about covers what's coming, but today we're focused on the paperwork, and our first attorney is Glenn Smith. I've known him for, I don't know how many years? 11. Sounds like 11. He is the principal of Lifescape Elder Care Law and Estate Planning, specializing in elder law, estate planning, special needs planning, and long-term care planning. He's client-focused. He listens, understands, and creates personalized plans that reflect your values, goals, and what matters most. He is a trusted and active leader, a member of leading elder law organizations, accredited VA attorney, and dedicated to serve the Kansas City community. And we are so proud that he is here.
Perfect. To my right is Diana Matienzo. Diana and I have been working together for years. She is a branch manager for Alliance Title. And I asked her to join us today to share some of her experiences and talking about deed fraud. And, you know, just because you may be listed on a will as or a power of attorney, she still cannot sell and record all the paperwork without specific documents. So Diana and I have worked together for, I don't know, 20 plus years it seems like. Is that long? You're way younger than I am. Okay, but anyway, But we'll be visiting with her. She is a retired Marine, once a Marine, always a Marine. So you're not retired. She's not retired. Sorry, she is a Marine, and she's my go-to for all of our title work whenever we close a home. So any of you that are joining us today who have closed a home with us, Diana probably did the closing, or her team did. So. Over 2 decades of experience in title and escrow work, and she has guided thousands of buyers, sellers, investors. She keeps up to date on all the laws and rules. So if you do own real estate and go to sell it, she's the one that helps record it and make sure everything is processed properly. So Diana is a mom of 2 boys, 2 huskies, and a couple cats. Down to 3 cats. So anyway, Diana, thank you for joining us and being a part of this. The other gentleman in the middle gets to go last. This is Joe Van Amberg. Joe is an attorney in Platte City, grew up in the Northland, went to school at North Platte, or West Platte, that's the wrong thing, in Weston. He's one of these Northland boys. Went to West Platte, attended Truman State University and the University of Missouri, Kansas City School of Law. So he is with a law firm called Witt Hicklin, thanks. Snyder and Fang. We're going to get his name listed on there too, so I'll make sure they have it for you. Anyway, his background is with family planning, estate planning, probate. He is actually in the process of updating my husband's trust and will and all of those documents. One thing I know that's a fact is we are all going to die. And that's sad, but it's the truth. It is a fact. And it's getting everything put together. And Joe has practiced and been helping families with their estate planning, from drafting wills, durable power of attorney, trust, beneficiary deeds. If any of you know what all of those are, I'm proud of you, but a lot of it is words that you hear and you may not know. So I wanted him to join us and navigate some of this for you, your children, your parents, any of that too. In my eyes, I want to make sure that we don't give more money away. And are there things that we can be doing to save your money and help not only you, but also your families? So there we go. Anything else? We good there? All right. Well, we'll jump into some of the questions. And we've kind of directed some questions to ask everyone for our panelists. And if you guys have questions, we'll do Q&A at the end. We also would really love for you to stop by and visit with our different community partners that we've invited. Each event will have different community partners. Parkville Living Center is located downtown Parkville. Marcus is over there if you'd wave your hand. This is a new organization in Parkville that's phenomenal. Helping. It's a place where they do community forums. They have bingo. They have different activities. Thanksgiving dinner they serve. So super proud and honored to have you here, Marcus. And we'll have you on another panel. So thank you for joining. Marcus is also going to be working with us on another seminar that we're going to do on technology. We've had several people ask us, what passwords? What's this? How do we do this? How do we do online banking? And Melissa and I both have talked, and we'll leave it up to our legal panel, but we have heard that, if you use your thumbprint or your eye to get into your phone and your password, when you pass, we can't necessarily go get your fingerprint anymore to get into your phone. Things like that we are seeing with clients. So Marcus is going to be talking about some of the technology and things like that. So awesome. Well, let's get into our fun questions. I'm going to start out with Joe. Joe, talk to me. Wills, trusts, do you need both? Do you need one or the other? Explain what they both are and what you need.
So everyone's favorite lawyer answer is it depends. So first off, differences between a will and a trust. When you're doing a will, that is a document that says, this is who I want my stuff to go to after I die. When you are doing a trust, you are creating a separate entity. This is kind of like creating a small business. It's an entity that is going to own your property, and you're going to have a trustee in there that is going to be in charge of managing your property and then distributing it. And there's a whole bunch of rules that we don't need to get into here. But as far as do you need both, for a lot of people, at least in my personal opinion, if you've got kind of the basics. Like, maybe you own a home. Maybe you and your spouse have a couple vehicles. Maybe you own a joint bank account. Maybe you've got a few investments here and there. Maybe you've got a couple of kids, get along, everything's great. May not be a trust situation for you. So I would say not everyone needs a trust. Does everyone need a will? Yes. I think everyone should at the very least have a will.
All right. What is in my real estate world? So now I'm giving you real life experience here. So Joe and Sally Smith have a will. They die. How do we avoid their house going to probate?
And I think we've got someone else that's going to be talking about beneficiary deeds. So when that conversation comes up, the way you avoid a house going through probate is a beneficiary deed. You can also put the house into a trust, but I would say the simplest way is beneficiary deed, which I will not steal your thunder there. But yes, that would be.
Okay. How old should someone be before they do a will? Go back to the will.
So it can be any age. I've had people come into my office in their 80s. I've had people come into my office in their 20s. I recently did a durable power of attorney for someone that's getting ready to go to college in the fall, just graduated high school. So there's no real age, I think, when it's required, but the sooner you get it done, the better. Because the thing to keep in mind, and a lot of people don't realize this, or at least don't think about it, once you have an estate plan, you can always modify it as you go. You are not stuck with it after you decide not to that day in my office.
Quick question. Yeah.
Okay, I have a will, but what does it really do? It just tells my cousin that she gets the piano, but who's, explain that a little more.
So, in your will, the way I like to describe a will is kind of like a safety net. So, we'll probably be talking about beneficiary designations, and there's going to be a question here about what's the one thing I wish everybody would do if you take one thing away. Beneficiary designations. So your bank accounts, put beneficiaries on those. Your investment accounts, put beneficiaries on those. Your vehicles, get a TOD on the vehicles. That is a transfer on death. That can be done at the license office. Those types of beneficiary designations avoid probate. Your will is there to catch what gets forgotten about. Like, let's say you forgot about that bank account you opened up 20 years ago, which all my clients swear they don't have, but yet their kids, end up coming in there and be like, oh, Mom forgot about, the bank account that, she had opened, 35 years ago, and it's been gaining interest, and now here we are. So the will is there to catch that. Wills are great because they keep your personal representative from having to go get an insurance policy on all of the property, which is expensive. It names who you want your personal representative to be, and just kind of helps guide your personal representative through the court so it's not as cumbersome.
So it's really for the judge.
In a sense, but also for your beneficiaries and then for your personal representative. And it will end up saving them a little bit of money in legal fees and then other fees as well.
If all you have is a will they potentially still go to probate court?
If you don't have beneficiary designations on your accounts, yes. If you don't have a beneficiary deed on your house, yes.
So make sure,
Ding, 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 yes.
So Diana just said a will does not transfer title. And so that's why I wanted to bring that up, is because we do see that in real estate. So just because you have a will does not mean the kids own it, the kids can sell it. So, okay. You mentioned something, Joe, about a trustee. I've also heard the word executor. What's the difference between those two names or people?
So a trustee is basically the person in charge of a trust. An executor is someone in charge of an estate, like a probate estate. In Missouri, we call those a personal representative. So if you hear the word executor, in my world, it's a personal representative as well. They mean the same thing. But trustee is dealing with the trust, executor / personal representative, probate estate.
How do you pick one? Or either of those? Do they
So
have to be family?
they do not necessarily have to be family. Now, I will tell you, Glenn and I have been to a lot of similar continuing legal education seminars, and one of the things that the trustee panels like to tell you is when you're picking a trustee, it's like, well, which of my kids should I pick as my trustee? And the not so funny, but kind of funny joke is, which one do you like the least? It's a lot of work. And a lot of people don't realize that. So you've got options, family members, friends, other relatives. On the trustee side, you can also do a corporate trustee if you want. We've got banks and trust companies that will do that for a fee, obviously, but they bring a lot of knowledge and can assist you along the way. As far as personal representative, kind of same thing. Which of your family members or friends do you trust to handle your affairs after you pass away? It does not need to be the oldest. Some people, their youngest or their middle child is the most responsible one. So they'll kind of get that.
Excellent. What, I think we kind of talked, one of my questions is, what happens if someone dies without a will?
They go to probate court.
How long does probate court take?
It could take a year. It could take 2 years. If things get real contested, this could be 3 or 4 years. I've had one because the real estate was taking forever to sell. I think we're on year 4. And there's another one, and I started in November of 2022 at Whit Hecklin, and I inherited an estate that had just started. We're still finishing that thing up. So it could take a while.
If they need a good realtor, I know one.
Excellent.
Just making sure.
These things are wonderful. Absolutely wonderful. Make all sorts of
Awesome. So here's something that someone asked us. Again, a lot of these questions people have asked us that we're visiting with, but can someone contest a will? Like, since my parents are in the audience, I'm going to use this as an example. Like, what if I don't like what they did? Can I contest it? Just kidding. Someone else brought this question, Mom and Dad. I'm going to get in trouble already.
You can, but you do run the risk of being cut out. So a lot of wills will have what we call a no contest provision. And a laundry list of things that you do. If you do one of those things, you're gone.
If someone selected me or anyone in the audience to be an executor or trustee or what was the Missouri one? Personal representative. What things do I need to know if I'm asked to do that? What do I need to perform? What should I know? And
so one of the things that a lot of people will do is if they have a loved one who passed away and they find a will, they've been named personal representative, one of the first things they'll do is they will call the attorney's office who prepared the will and say, can I have an appointment? I just have questions. So they will come in, we'll try and answer as many questions as they have, and then kind of give them some guidance on next steps. Because a lot of times what their questions are is, do I have to go through probate? Do I need, like your services for anything? And we can kind of walk through that. So I would say one of the things you want to do, if you've been named personal representative and have questions, make an appointment with a lawyer and we can talk through that.
good.
I was the executor personal representative for my grandparents. And when you're picking your person, in my opinion, it needs to be somebody who can handle the cousins and the siblings who are coming after you with the questions, where's my part? Can I say that politely?
Yeah, and just to kind of follow up on that, excuse me. One of the things to keep in mind too is when you name one of your children as a trustee or personal representative, depending on the assets and kind of how that's going to go, you could be changing the relationship between those siblings because now it's not brother and sister, sibling and sibling. Now it's someone who is paying someone else some money at some point. So keep that also in mind when you're making this.
Can an executor be paid in part of the will if there's a lot of work to be done?
Yes. So one of the things is, and this is kind of getting into the probate statutes, but there are laws that do set a personal representative's fee, and it's based on how much money is in the estate, and it's in the law, so you can just calculate it, on that. But yes, they can get a fee for their services. And typically they're allowed reimbursement for any expenses, personal expenses they incur.
The reason I asked him is on that one is I do have a friend who she had a close friend pass away of cancer. She asked her to be the executor, and the friend has since passed away in November, lost her battle to cancer, and now she's taking over, executing everything as her executor. They're in the state of Kansas, and she said, Audra, I'm learning so much about this. Number one, my friend hadn't filed taxes in the last 2 years. Her adult children are asking me for money and want their part of what they should be getting. However, I can't give them anything until we file all the taxes and go back and pull all this information and take care of all the legal and medical stuff first. So she's dealing with a lot, and it's been very eye-opening. And as Melissa and I have been putting this together, I've had several conversations with people. You've had a parent pass away, or a friend, or you're an executor. What things do you wish you would have known? And another friend of mine shared an experience that she has a sister, and mom and dad said, we want both of our girls to be the POA for medical and financial. Makes sense. There's 2 daughters, right?
They like each other.
They like each other. It was the daughter, both of them have told me this, it was the worst thing that their parents had put them in, that situation, because dad told one daughter he wanted this, then he told the other daughter this. He now has dementia. They don't know what to do. And now dad needs medical treatment, and his health was failing, and the daughters were fighting. And the doctors looked at them and said, I know you both agree 100%, we're not doing anything. So now dad is sitting here in the hospital waiting for the 2 daughters to agree on who's right of what dad said. So it just was eye-opening visiting with people, and you think you're doing the right thing. Mom and dad have, 2 daughters. They loved them dearly, but they now are disagreeing, and it has really hampered the relationship. And even listening to you kind of share some of that stuff. Talk to me about general planning. What documents, I know you kind of briefly said one, but I'm going to ask this again. What documents should every adult have?
So if you own a home, beneficiary deed. Other than that, durable power of attorney, a healthcare directive, and a will. Those would be, I think, the 4 big ones that everybody should have. And like I said, others are going to talk about the powers of attorney. The question of trust is something that you and your attorney can talk about if you meet that, but those documents I just think I would say are big ones.
Glenn, you're over there. I know we haven't asked you any questions yet. Do you agree or disagree? And it's okay to disagree.
Feel free. Not disagree with Joe.
All right.
I would probably, scale of 1 to 10, what's most important is everyone that's 18 or older should have a financial power of attorney, healthcare power of attorney, and a living will. I have had 4 cases of people that were on the way to college who had horrific accidents, and their parents were surprised that they had no authority to make healthcare or financial decisions for their parents, and they wound up in probate court in places in Kansas and Missouri where they did not live. So do your kids a favor, grandkids, when they turn 18, get their powers of attorney. It will make everybody feel better.
Amen. I've heard more and more stories. Go on spring break to Padre Island or Florida and something happens. As the parent, you have no control if they're over 18. So for children, grandchildren, Belinda, you and your daughter and son, like they have houses, make sure there's a health. So what's it called again? POA of health is my terminology. What's it called?
Healthcare power of attorney.
Healthcare power of attorney. Okay.
A
Thank you.
living will is sometimes called a healthcare directive that Joe was talking about. That basically says if I'm brain dead or vegetable and I hope that I'm going to pull out of it, make me comfortable, let me go, rather than put me on a respirator or feeding tube for a long time.
All right. Well, I'm going to hand the microphone over. Melissa, you good to ask Glenn some questions? We'll go over questions with Glenn that we put together. Glenn, you get the microphone. I know you don't like it, but I'm recording, so I need to know to hold it. Love you.
Some of us think we have voices that we don't need a microphone, but, so Glenn, you and I are in the elder business. So what is elder care law and how is it different from regular estate planning?
Elder law or elder care law is the practice of law that focuses on folks that are aging and their families, thus elder law. And we typically see families before we see some of you. It's the kids that are the ones that are typically interested in getting things settled. How does that differ from estate planning? Estate planning is a subsection of elder law. If you do elder law, you're going to do typically estate planning, special needs planning, probate, and trust administration as well.
What about, one of the things that we're all concerned about is long-term care. You know, it's going to be expensive if you have to go to the nursing home or have senior helpers come to your house on a regular basis. How's some of the ways they can pay for that, and what happens if they don't have ways?
My wife and I went to Yellowstone National Park last year, first time. And what I noted, because you'll know who I am before I stop speaking, there are planners and there are non-planners. My wife was the planner. I was not. Planners make reservations. They have maps. They know where they're going. They've packed appropriately for where you're going to spend your time for a variety of environments. I did not. It's much more expensive for non-planners. People that don't plan can only have choices based on what's available. And guess what? It's always more expensive for non-planners. Whereas if you're a planner, somebody that looks ahead, you're going to have your team of people put together. Who's your doctor? Who's your attorney? Who's the CPA? Are they talking to one another? What are the resources we have? If and when we're part of the 70% that need long-term care, where do we go? What trigger events do we have to occur for us to move from our home? What trigger events would have to occur for me to give up my keys? I've had conversations with some of you this afternoon talking about your parents.
By the way, it wasn't me. Okay?
Who said, I don't want to talk about it. The filter came off my mouth a long time ago. Been doing this 43 years. That's silly. Somebody needs to have a come to Jesus moment with the seniors. You do yourself you do your children a great disfavor if you don't have a plan that is written out and well known and worked. So if you plan, it's less expensive, better care, less chaos, and you live longer and better. If you don't plan, it's the opposite of every one of those. So we see 10 to 15 new families a week. Most of the people that come see me, their hair's on fire. Meaning what? They waited until the crisis. So, I'm not being cynical. I procrastinate myself. But you're here. Plan. It's less expensive. And by the way, we'll talk about when you ask me about some finances and ways you can finance stuff.
Well, what's the biggest mistake families make when planning for long term?
Well, that's fairly simple. They don't. there's a difference between estate planning documents and long-term care planning. Documents are tools. It's not the destination. Estate planning is a tool, but estate planning are documents that do not execute themselves. More important to long-term care planning is what I, particularly looking at 5 different areas: housing, healthcare, financing, and your legal documents, so it serves other things, and support for the caregivers. Support for the caregivers. So the biggest mistake is failure to plan in those 5 areas. The second biggest mistake is most people have advisors. You got a financial advisor, you may have a banker, a lawyer, CPA, and all of them have a plan for you. Unfortunately, they don't talk to one another. So you've got what we call the Swiss cheese approach. Everybody's got a plan, but there's these huge gaps. So the other mistake we see is you have not communicated your plan effectively to the entire family. And that means civil war is on the horizon. Like someone's already said, people question the directive. So good long-term care planning looks like instruction manuals. You go through, I'd say the newest thing on the horizon right now for long-term care planning is what's called a dementia directive. Healthcare directives and financial powers of attorney do not address the intricate things that need to be decided relative to dementia, Alzheimer's, Parkinson's, MS, and the list goes on. So the smart thing is to do those type of instruction manuals so that you are in charge rather than someone else, so that you minimize conflict in the family. By the way, opinion. Just because they're a child doesn't mean they need to be an agent. Some of them are jerks, some of them are idiots, and some of them should not be trusted. So just remember, it's okay to make them mad. You're the boss, you're the parent. Be the parent. Make the decision. I'm preaching, I'm sorry.
Glenn, I like that you shared that information. During some of my due diligence for this, I spoke with a friend that I grew up with. Her father was an attorney. He passed away. So being an attorney, he had everything written out and coordinated. However, he had not shared any of that with his kids. And unfortunately, it was a heart attack, so it happened quickly. But he had everything in, what's it called, safe deposit box? No, what's in the bank?
Yeah.
Safe deposit, yeah. Had it everything in there. So they found a key and went and pulled it out. So my friend is telling me, we see all this stuff that my dad put together. We didn't know about this and this. And so it was kind of the Swiss cheese analysis of putting things together and filling in the gaps and everything else. And she said, on the other hand, my stepmom passed away, and she was the planner. She literally had, when I die, here's who I want you to contact first and who they are. Here's their phone number. Here's who I want to sell my house. I'm giving myself the chills because she listed my name, and I helped them sell the house. She got that detailed in what she wanted. Here's this charity, I'm on this board, I want this organization to be identified and recognized. She had all of her credit cards listed, phone numbers, different things like that. So what she did was she shared all that information with me. I am in the process of putting together a Google sheet that I will share with you. If you're tech savvy, it's amazing. But it's literally an announcement. She literally wrote her obituary. I've written mine. I'm 53, but there's things that are important to me that are near and dear to my heart, but I don't know if my kids would know what that means. And it may sound morbid, but here's some things. Obviously, kids, you can tweak it and do whatever you want, but why not share? Like, she had shared the music she wanted played at her funeral. We have Myers Funeral Home here, or they were, but those are things that are important. And I think just putting the plan together. There's another book that I bought that a friend told me. It said, and I'll email you all since you did sign up, but it's called I'm Dead Now, or I'm Dead, Now What? And it literally is to hand to your adult children or whatever, and it's literally your plan. I don't like papers, as I think my mom probably knows, so I want everything computerized. But if you're the handwriter and you want to write those things out, it's again putting a plan together for people to know about, and listening to my friend who daddy thought he had everything, but he was missing things and it was in a box that no one knew about, versus stepmom that literally got the extremely detailed. So yeah, it's just your plan and what you want. So I love that.
As a PA accredited attorney, what benefits do veterans and their spouses often not know they have?
The two most prevalent low-hanging fruit for veterans is number one, it's called aid and attendance. If you or a spouse had served at least 90 days in active service, and one day during a declared time of war, and there you can look up the dates, the benefits are tax-free. It's about $3,700 for the veteran up to that amount, and up to $1,800 for the surviving spouse or spouse. Really fairly easy to get. And the other one is the veterans' homes in both Missouri and Kansas, particularly Missouri, the 7, are top-notch. You would consider them 5-star facilities or communities. There's usually a 1 to 2 year waiting list. People don't know what they don't know, but it's a free deal. So those are the two that you need to know about. Now, let me get on another. You know what the biggest mistake for a lot of folks is? They wait too long to get benefits. You got the long-term care insurance policy. You may have Medicaid, you may have VA benefits. People wait to come to get those benefits, and frequently too late.
I hear it all the time.
They could have gotten those benefits for years, but they were afraid. They thought they were going to lose everything. And we've had, fortunately, 3 cases in the last 2 or 3 weeks where people came to us and then they passed away 2 or 3 weeks into it. And you just wonder, why do people wait sometimes years rather than get the benefits to help the caregivers, to take the burden off the family, to get good care, better care, 24/7 care, and it's free. I just don't get it.
And I would let you know that some people tell me that they don't get along with their siblings, they don't know where to start, all the different things. I kind of specialize in family dynamics and grumpy old men. So I am always telling people, I am happy to come be your advocate and help the family move to whatever the next step is and to help coordinate that. The number one thing I'm told with senior helpers is every single family at the end of their folks' life says, I wish we would have started with you sooner. When you start with help sooner, the cost is this much. It prevents falls and other things, and that cost can stay small for a long time. But when you wait till crisis mode, now your bill's this big, and it doesn't go down, right? People say, oh, mom's going to get better. Usually not. So as we go back, that kind of brings up Medicaid. People think, oh, I have a house. Can I get Medicaid? Do I not have a house? How does all the Medicaid planning work?
First of all, misconception, myth, lie. and that is Medicaid is only for the poor. Medicaid, from my perspective, is the long-term care plan for the middle class. I know Audra told me that most of y'all are filthy rich, and this does not concern you. But if you have less than $2 million, Medicaid can be a very viable source of income for if you're trying to pay $12,000 to $15,000 a month for long-term care, or the $7,000 to $23,000 for home care. Let the government pay those sums, and then you use your own assets to get premium care. Let the government pick up that 12 to 15 to 17, and you supplement that. That's number one. Number two, and I'm going to truncate this, and what I say, I believe, and we do every day. If you're married, the well spouse can keep 100% of the assets. And the spouse that needs help can get covered and get all their care paid. If you're single, then you can keep around 60% of your assets and get the government to pay for your care. There's no fraud. It's not illegal. We tell the government everything they do. Now what happens is most people spend all their money and then they go out and look for options to say, I need help filing Medicaid. And I've been sitting there in my mind saying, oh my God, if you would have only come and seen something 2 or 3 years ago, you would have kept all your money. You didn't have to do that. You didn't have to sell your farm, ranch, or your home. You don't know what you don't know, so we'll find out.
What's the 5-year look back?
5-year look back simply means if you transfer your assets to another party without consideration or inadequate consideration, you will be denied benefits to the extent of that uncompensated gift. So one of the frequent things we see is mom and dad transfer something to Junior or the daughter, thinking that's a good, appropriate way to have your cake and eat it too. What they've just done is saying, yeah, I transferred it, because there's a question on the test that says, have you transferred assets in the last 5 years? Now you can lie, and the government finds out and they deny you benefits, or you'll just say yes. So you can transfer assets, but you need to do it the right way to avoid the consequences of that 5-year look back.
So what about a durable power of attorney, and why does somebody need that before they actually need it?
Durable power of attorney, let me tell you what it's for. You authorize agents to help you make decisions or act on your behalf if you cannot or if you need help. Now, you didn't ask, this is a freebie. More often than not, you need to have your power of attorney start helping you long before you're declared incompetent. You don't wake up one morning incompetent. It's a slow walk down the hill, right? So, word to the wise. Trigger your power of attorney before you get declared incompetent. Before we have to go to probate court. That's the biggest problem we're having. Your power of attorney says you have to be declared incompetent in order for your agents to help you. By the time you're incompetent, we can't get you to the doctor because you won't go. You fight us on everything. Guess what happens? I call Joe to take you to probate and have you declared incompetent, which pretty much makes that power of attorney worthless. So, when you're in your 70s, 80s, trigger the power of attorney to be immediately effective. You can still continue to make decisions, but you don't have to be declared incompetent in order to get the help that you need. It's really a smart thing to do. Now, second thing about the durable power of attorney, you walk into an elder lawyer's office. First thing I'm going to ask to see is your power of attorney. Frankly, I don't care about your trust or your will, because they're almost irrelevant for what we're dealing with. I'm not saying they're not going to be important, but your power of attorney is the key. A power of attorney, if you're smart, will have in it what's called enhanced powers. Most powers of attorney will copy the state statute, which is law, slap it in the document, and it works for most things. But if you're looking to save money, keep all your assets, give your assets to your spouse or your children if you need help, change beneficiaries so that you can keep the money, it has to specifically say all that in the power of attorney. Okay? If it doesn't say in the document that you can do something, then you cannot. It's a pretty short conversation. You come in, let me see the power of attorney, and then we're either going to be able to save you a lot of money and get your care, or you're going to spend down until you're almost broke. It's a big deal. So if you have a power of attorney, have it reviewed for purposes of those enhanced powers.
And Glenn, one thing that I've seen in real estate that we've had clients, and Diana and I deal a lot with this, with your power of attorney, if they're, here, I'll take this. What we've seen in the real estate world is if you have a power of attorney for financial, and again, I'm not an attorney, so please correct me, but they can't legally, if they aren't, I'm just going to use, I had a client that has dementia, so he couldn't sign the paperwork. Diana needed that POA that says who's making those financial decisions, and it needed to address the address, right, Diana? Like, what do you need on the end of selling homes?
It doesn't go with the legal description of the address, but we need to make sure that it is durable.
Put your microphone.
Oh, it has the correct durability language in Missouri. And we're also going to look at, was he competent at the time that he signed the power of attorney? So we may require 2 doctor's notes stating that at the time this was executed, that he was of sound mind, or he or she was of sound mind. And I can attest to that. Just my parents both died from dementia, and my dad was actually in a dementia nursing home, and just in conversations that we heard from other family members, to where they were just like, oh, well, you know, we'll just say that dad was fine when he signed this. Like, that's not going to work, because he may not agree with what you're giving the powers to. And we see it a lot. That's why we ask for this doctor's note, say, hey, this person of sound mind, the doctor tests their sound mind when they sign this. Now, there are times when someone may be further along with dementia, but if they're like of sound mind, like in the morning, which is the best time to talk to someone with dementia, you know, that doctor's going to test when this side they were of sound mind, even if like later in the afternoon they have sundown, even if they have no idea what's going on, at least we'll know in the morning that they were of sound mind. Because we had to do that with my dad. We had to have another power of attorney drawn up, and we had to do it in the morning to make sure that he knew exactly what was going on, to make sure
Use the
he didn't have
microphone.
questions.
Oh, I'm sorry.
Oh, I'm sorry. So we had to have a power of attorney redrawn, and the elder law attorney that did it for us had to make sure that he knew what was going on. He knew he was given those powers to, just to make sure that those were his wishes. Because later on, if we would have done it, he would not even know, but he would disagree with anything that they're doing. So that's why people hate it when we ask for that letter, but there is a reason for it.
One other item you might consider if you've got a power of attorney, take that power of attorney and your agent, walk into the bank or the financial institution where you bank, and hand them that power of attorney, introduce them to your agent and say, now look, I want you to review this document. They'll send it to your legal department. And I want you to tell me that you're going to abide by this document if this person comes in. Don't jerk them around. What happens often is your agent will walk in with that power of attorney when you're incompetent and want to utilize it, and the banker will say, man, that's a long document. We're going to send that to our legal department, we'll get back to you in 6 to 8 weeks.
Wow.
So cut that stuff off and get it, show them the document, introduce them, tell them it's okay.
Thank you. Super helpful information. And I think just through different personal experiences, from the dementia cases that I literally had to ask a client for their medical in order to sell the house. The wife's fine, husband has dementia, and they had to provide a letter that we gave title for their legal counsel to prove that he actually did have dementia. And another case, same thing, mom has dementia, son is POA, but had to make sure identified the address. So Diana, in order to sell homes, again, people's largest financial decision, if those paperwork, if that's not put together, we're in trouble. So, all right, back to you, sorry.
We kind of touched on it, but is there anything else we need to clarify on the difference between a financial power of attorney and medical power of attorney, and what happens when someone is incapacitated without one?
Well, if they're incapacitated with no times of being lucid, then I call Joe. Joe takes them to probate court, and then the probate court controls everything from that point forward, including the budget, the use of funds, the annual reports. And if you think talking to an attorney is expensive, try talking to an attorney while they're in probate court. When I was a young attorney, we would give away our wills because we waited till you died. Then we would make all our money on the back end. You could, if you're real smart, you get all this long-term care and your will done, then we can't make our money. So it's a much bigger approach.
Where do you recommend people keep their copy of their POA or wills and trust? And the reason I ask is Diane and I helped a client this past year for over a year that dad passed away, mom had it in a box, and daughter we were selling the house and getting rid of everything, and she accidentally shredded it. And it was not fun. So it was a fiasco. Where do you recommend? Do you have one copy? Does the attorney keep it? Is it recorded somewhere?
So-
Where is all that info?
So
Can you put the microphone up to your so
the attorney does have, we both keep copies. Copies work for almost everything, except the last will and testament. You need the original of that. Safety deposit boxes are way too small to put that stuff in nowadays, unless you want to spend a few $100 a month or whatever it is. And so the attorney's got a copy, your agent, personal representative, trustee have a copy. It's on an electronic drive, shoved into your computer so that we can share it with people. I advise my clients, give a copy to the people that have your money. If you've got a financial advisor, give it to them. So the originals, have a place at home where everybody knows where it is.
Yeah, and I just kind of want to echo that. Talk to your family members about where your important documents are, because like you just mentioned, when a family member passes away, the family is grieving and they start going through stuff. They are not in a state of mind to be looking closely at what they're throwing away versus what they're keeping. So you can have that conversation and say, hey, it's in the safe. Here's the combination of the safe. Or hey, it's in my desk in this drawer. Have those conversations with your family well ahead of time so they know there's where the important documents are. We're going to get those. We're going to put those in a safe spot. Then we will go through everything else. So just have those conversations and make sure your family knows where these documents are.
All right. I want to get into Diane, and I'm also conscientious of the time. But one more for you, Glenn. Hold on, Glenn. Keep on my phone. I'm just keeping you on your toes over there, sir. I am seeing more and more scams. Diane and I are in the real estate world, and it makes me sick to my stomach. what do you, what legal scams are you seeing with our seniors? Don't laugh. Yeah. I mean, there's everything out there. It scares me. Do you have any words of wisdom to share with our audience, both online and in person here?
Well, the reason I snickered a little bit is I'm looking for scams every day on my computer. I mean, how many of y'all get something from the Prince of Nigeria or things that look like they're from Chase or First Federal, and they're just wanting you to click and give them information. And we've got to spend a lot of money on security in our firm. So the boyfriend-girlfriend issue, new study out from the National Council on Aging, probably the largest study I've seen, 600 something participants who looked at 21 different cohorts on this study, and loneliness, of all things, loneliness and isolation is one of the number one reason people get dementia, Alzheimer's, and Parkinson's. 31% increase if you live alone and have minimal interaction and watch a lot of TV. So what we see frequently is the girlfriend in another, or the boyfriend in another nation gets them hung up on the internet, and then they're told they need money because they've been kidnapped and need a kidney transplant, and they go to the ATMs or the, what do you call it, crypto machines in the gas stations. 200,000, 500,000, 50,000. Those are my cases. These are smart. I can't tell you the organization. I had one executive director of a 501c3, big one around here, who called me, and she's telling me this story, and I go, that can't be true. She got snagged for a few $100,000, and this was an executive. So yeah, they're out there, and the more lonely you are, the less community you have, you're a set middle.
I personally have been involved in a couple. One of our clients, the caregiver, was asked to go to the bank to get a cashier's check for $26,000, all of her savings. And the caregiver said, no, what do you need a cashier's check for? Turned out the FBI called her because her bank was having trouble, so if you want your money to be safe, please send it to the FBI. So she was really, really mad that we wouldn't take her to the bank. So in order to get her to calm down, my caregiver decided to call the FBI. Lo and behold, they answered the phone. And they do not take it lightly that someone is impersonating them. They were on her doorstep before my caregiver could leave. Over $26,000. Obviously it was a scam. We stopped it, but it took her 2 weeks to talk to my caregiver again because she was embarrassed and so mad at us. Now, after the couple of weeks she got over it, she was very grateful that we stopped it. Another one was a caregiver, our client asked the caregiver to go to Walmart and mail this package. And I'm not very sure why it was at Walmart we needed to do it, but I'm glad it was, because they have a little station for check cashing. And that girl's good. I'm just going to tell you. She handed her the envelope and says, hey, here. And she said, oh, what's in here? And she said, pictures, because that's what we were told. The lady said, this is cash. I can tell. Okay. So they opened it up, and it was $4,000 in cash. And we were sending it to some dude in Texas. We didn't know. So I took it back. I waited the next day and went to her house and said, hello, here's your $4,000. And we took pictures and counted it together, so we had accountability that it was how much it was. And she was all there. she was so upset that we stopped it because, oh, it was just a mistake. I was supposed to hand, and she had pictures on her counter, and she goes, I was supposed to send these. I'm like, those were not pictures you were mailing, but okay. But they also don't like to be embarrassed or caught or feel bad, and so we have to work around it and help them navigate. I do also do the come to Jesus meetings and help take the keys away with families. I do all those kind of things. I'm not your typical owner.
Well, and I think with scams and different things like that, Marcus, I'm looking forward to having you join us talking about that. Different age group, but there is another scam that's going on out there that mortifies me. I think because I'm a boy mom, but it's called sextortion. And it's happening throughout the United States, and they're targeting young boys and trying to be a girl, and same thing. I'm out of state, and I want to be your friend, and all of this, and getting young boys to take private pictures of themselves, and then they're saying, now you need to wire $3,000 to $5,000 to our bank account within 24 hours, or we're sending this picture to all of your Instagram friends, Snapchat friends, parents, all of that. It has happened in Platte County. I'm aware of a couple different cases through my boys' school. So there are so many people out there. I at least once a week get an email from Costco. Well, for those of you who know me, my husband works for Costco. So Costco doesn't give away Yeti coolers. I already asked him. The email says we're giving a Yeti cooler, apply here. I look at the email, it's some Gmail account from blah, 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 blah. It's a scam. They're all over the place. So another reason I want to be the mama bear. I want to try to help people and protect them. Let's talk about some scams going on. Diana, talk to me what's deed fraud? Yes.
Can we go back to talk about some of the things they went over real quick from
Yes.
a company standpoint?
Diana, I want her to go over some stuff. Yes, let's go over those things that we've talked. We've talked a lot about
So things that they've
different things.
spoken about, I'm going to tell you some things based on the title company standpoint. When it comes to the power of attorney, we have to have the original in order to record it into the public record. So there's a lot of people, when they can't find that original power of attorney, we can't use it. We cannot allow that power of attorney to be used because we don't know if it's a forgery, because there's a lot of elder abuse going out there. And we want to make sure that those people are taken care of. So if you do not have that original power of attorney, you're gonna have to find a different way to, maybe just go to court and have someone assigned to the property, because we can't do it with a copy.
How do you know if it's original or a copy?
Honestly, we flip it over and we put our finger on the back to see if it's indented. I mean, there's really,
Okay. I mean, I didn't know as an adult, like, okay, what my in-laws said, here's your power of attorney. How do I know if it's...
you can tell sometimes by the ink that's on there, or if it's been copied, there might be some lines on the side.
Okay.
But we will look at it to make sure that it is an original, because we don't have the original, we can't use it. Because we could also lose our right to record electronically with the county, because we signed an agreement with them saying we're not going to record copies.
Right.
So it's like we can get in trouble with recorder deeds, so we don't want to do that. Also regarding beneficiary deeds and transfer upon death deeds, which is transfer upon death deeds are on the Kansas side. On the Missouri side, since I assume my parents here is pretty much from Missouri. Some people don't realize when you do the beneficiary deed, and if you file a deed after that beneficiary deed, so let's just say mom was single, she filed a beneficiary deed and left the property to her kids. Then she gets married, adds her new husband to title. That beneficiary deed is no longer valid. So anytime a deed is filed after a beneficiary deed, it's null and void. And that's from Missouri probate statutes. So there's a lot of people that are like, oh, well, mom, she assigned the property over to me. It's like, well, mom added her husband to title, and he's still alive. He gets the house. And they may not realize that. And it may be a family house. Maybe that's where their parents lived together before, their dad died, and she remarried, had a new husband move in. So this is their family home. But they don't have the rights to it because she added debt to it.
Would they have the rights after he died?
Depends if he has a beneficiary deed, then he would have to do another deed to give them the rights. So a lot of people don't realize that deed is filed afterwards, it's null and void. Another thing.
Real quick before you start, just for explanation, I know what a deed is. What is a deed? I mean, help our audience. What is a deed?
There are different types of deeds. So the warranty deed is the one that completely transfers what's called fee simple interest. So those people that are currently in title and own the property, when they take that property and deed it over to a new owner, that is a warranty deed, and when they're signing it, they're warranting that they're giving free and clear title and that there's no title defects to that new owner. A quitclaim deed is exactly what it is. You're quitting your claim to the property, so you're eliminating interest. We use that a lot when we are changing names or marital statuses. If someone is getting a divorce, we'll file a quitclaim deed. Name changes, if people want to go from their individual names into the trust name or the individual to their LLC name, that's when a quitclaim deed is used. With the beneficiary deed, that is, you're still alive, and this is what your wishes are. You want this person to be able to have your property after you pass. On the Kansas side, it's going to be the transfer upon death deed, still works the same. One thing I want to keep in mind, I'm not an attorney, I just pretend to be one, so I'm not giving any type of legal advice when I say this. It's just things that I have witnessed as being a title closer for 25 years. Know who your beneficiaries are and what kind of people they are. So there's sometimes parents who are like, okay, I'm going to leave a property to my 4 kids. That's fine, but one kid's in prison. It's going to be hard to get that signature from that person that's in prison, and maybe the 3 siblings want nothing to do with that sibling because he killed somebody. We have this. It was difficult to get that guy's signature. Or let's just say that one of your family members dies. If you're not entitled as joint tenants, then all their heirs are not the legal owner of that percentage of the property that person owns. So you want to make sure when you're doing a beneficiary deed that you are putting the correct tenancy that you want. If you do not put joint tenancy on there, it's going to automatically default to tenants in common, which means that if any person that property was left to passes, then that goes to probate or to their heirs. This can be a little bit sticky when you have someone that dies and they have 12 kids. Their 12 kids have interest. If one of their kids dies, then their kids have interest. So imagine having, one time we had 23 people that had 1/4 interest. I'm sorry, 1/16 interest of a property. And those
How many kids are married?
the spouses just have marital interest. If you do the joint tenancy, that means whoever is your beneficiary, if any of them were to pass, and that interest gets passed on to the remaining people that are your beneficiary. And I just want to point that out because a lot of people don't understand the importance of tenancy. If you are currently, like I said, you bought your home and you're both single people, if you're not entitled as joint tenants, then that 50% interest is going to go to the heirs or to probate. So you have to you have to decide how you want your interest to go, especially when it's like a second marriage or a third marriage. Because it does get messy, and I'm going to call out Lisa because she's here. Because we had a file to where it was a mixed family where we had step siblings. They did not get along. Lisa earned that commission plus more. Let me tell you, it was a very hard transaction because you had people blame, like say someone stole money, and then like they're just going back and forth, refusing to sign. They want this, they want that. So make sure that have that conversation if you have a mixed family of what your intentions are, so that there's not a lot of arguments like we have this trip. I mean, it was pretty bad. So I just wanted to point that out.
No, I love that. I think that's one of the things that you and I experience the most in real estate is not having a beneficiary deed. Again, I think that's the easiest document you can get if you're a single person or married, whatever. Make sure you have that beneficiary deed. Not to take away business from attorneys, but I do know Diana at her title company, again, she's not an attorney, but they have legal counsel. So Diana, tell me like $300 or $400 to $200 to do it, to do a beneficiary deed, and then they record it. That costs another $32.
Oh, I'm sorry, it's going to go up to 35.
$35. So for $235, if you are single or married or whatever, at least do a beneficiary deed. So then that way, again, I'm not an attorney, so correct me if I'm wrong, but to me that just seems like the easiest thing for financial planning is at least have that document in place for the real estate. Because again, that's where a majority of our money, unless it's, in the stock market, things like that, but people have homes and a lot of equity in it. Make sure you have that document. Diana, we've been going over a bunch of stuff. Talk to me about deed fraud.
Deed fraud is becoming one of our top white-collar crimes. It's up there with embezzlement and wire fraud. But what they're doing is that these fraudsters are looking for properties that have no mortgages against them, land, or, believe it or not, they're reading obituaries to see who's died. We had a file that we did examination of the title, and mom had passed April of the previous year. Dad died that following September. The day after dad died, that fraudster recorded a deed, forging the parent's signature and giving it to someone else. The notary wasn't even legit. People are stealing our notary commission stamps and just signing our names. So our commissions are being used illegally by people. And if you live in Jackson County, and I'm not trying to talk bad about a county, but I'm going to talk bad about a county, they really don't pay attention to what they're recording. So they'll record pretty much anything. We have seen it to where we could tell that a notary block was attached to a deed and wasn't even meant for that deed, and Jackson County is still recording it. If you live in Platte County, you have the absolute best recorder of deeds. Please, please, please keep voting him in, because he is doing everything possible to eliminate deed fraud. He's actually going across the United States, seeing how other states are handling it, because it is becoming a very big deal. So what you can do in Platte County is that you can do a self-imposed lien against yourself. So you can just go to the recorder of deeds and say, hey, I want to put a lien against myself in the title. So if anybody tries to sell that house, they can't, because you put a lien against it. And the only way to release it is that you go back to the recorder of deeds and release that lien. There's also free deed monitoring services that is available on Kansas and Missouri. The only county that doesn't have it yet is Johnson County, Kansas, which baffles me that they don't have it. They said by the end of the year. But I do have business cards back there in the back that you just scan the QR code, and it takes less than 2 minutes to put your information in there. And what happens is that if anything is recorded under your name, you're going to get a notification from the county saying that something was recorded. If it's not legitimate, you just go back to the recorder of deeds and say, this is not me, I did not sign this, and there's like the investigation. So if you've heard of title lock, which is something that is out there on the commercials and stuff like that, it costs money. This is free from the counties.
I like
So
free. She said free.
So it's a great benefit. If you're in Jackson County, they have a different one. So Jackson County and the Kansas counties have their own. So I do have them separated. But it's the best 2 minutes that you can spend.
So Clay County and Platte County both have it. I would recommend, like my friends Bob and Kathy that are here, have your daughters be on the email too. I'm on my mom and dad's. My dad's name is very common, John Miller. How many John Millers do you know? I set it up so I'm notified, and I've got several emails, and I'm like, nope, that's not them, that's not them. Okay, great. They just sold a property. I got the email, I'm like, it's working, because they actually did sell it, and it was legal. But it's a good way, and it's free, so I will have those resources for everyone as well, too, that I'll share with you. Diana, what else? I'm being conscious of the time, so anything else that, are we good on time? Okay. Anything else that you think is important to share with our friends online and in person?
Well, you know that I'm a title nerd, so I could talk all day about this stuff. So I could talk all day about everything that I see. But just be vigilant. Just make sure that you are checking it. If you don't have an escrow account and you pay your taxes every year, make sure you're getting that tax bill. If you don't get a tax bill on the property, that means someone is taking that property away from you, because it's going to that new person.
One thing that I've found with Diane as well, a lot of times financial planners or your attorneys will tell you to put your home in your trust. So it's titled in the trust. We see that all the time. When we sell your home and Diana goes to disperse funds, there must be a bank account in that trust name. Now, my friend Joe, it's my new BFF, because he's helping me, and he's like, Audra, and you can tell me if I'm wrong, but I'm just repeating what he told me that I remember. Don't put your house in the trust. Do a beneficiary deed to put the house in the trust when you die. Did I say that right? Okay, that's the layman's terminology. So my house is, as soon as I sign off and say this is good, because he's working on it now, my house is still in my name. I'm putting in a beneficiary deed that says it will go into the trust when both my husband and I die. Then the trustee or whoever's in charge of the trust, all that stuff, again, I don't know. But we'll coordinate and execute that way. So that's a good way of doing it as well if you do have a trust. But if your house is currently in your trust name, please make sure you have a bank account in the trust, because
Cash the check.
you got to cash the check.
We're not getting these that we ask for. We're just doing our fiduciary duties.
So
I get yelled at a lot. So.
super important. Audience, you have questions? Yeah. Anybody have any questions?
While I'm going around to catch the questions, do you guys have anything, last thoughts that you want to include for our folks?
Super helpful. I appreciate you guys coming and sharing your expertise. And again, everyone's just kind of, it depends on every situation and things like that. But there's a lot of things that people can be doing to help set everyone up for
We have
success.
our first question.
Yes.
Hi, my name's Heather. Thanks for being here. I really appreciate all this great information. I'm wondering, this is going to be probably a stupid question, but is Medicare or Medicaid, does it vary from state to state? My mom's in Oklahoma.
The question relates to if Medicaid and Medicare differs between the states. Medicaid, not so much, because it's federal. Did I say Medicare? Medicare is federal. Medicaid is a joint project between the federal and state. So it varies more between states. As to think of Medicaid like going to a school cafeteria. You got a whole bunch of programs, and each program has different eligibility requirements. Those eligibility requirements differ per state. The one that is most common is what's called long-term care vendor care. Vendor care is for long-term care. That's the only thing that I see really differing between states, how much equity in the house can you have, and what's the maximum amount of resources. Kansas has 2,000. Missouri is, as of right now, $6,220.50. Very some, you didn't ask, but if I qualify in Missouri and I move to Kansas, usually it's just filing the documents twice, no big deal. So you can transfer between states.
Since we're so close to Kansas, Glenn, I've known several people who moved to Kansas because they could get Medicaid to pay for their long-term care quicker than they can in Missouri. Or is it just because they have some better communities over there that keep Medicaid?
Well, you know, there's been a lot of hoopla over that the last year, and we've been in contact with the state. They've instituted a lot of changes. I think it's faster in Missouri than it is Kansas. The procedures are easier in Kansas than they are in Missouri, but typically we're getting rulings within 2 to 3 months. Same for both sides. It's good.
Next question.
So when you were talking about taking your durable power of attorney to a financial institution preemptively, sorry, people change. It's gone to the legal department, but is there something that the legal department gives you that says we will accept this durable power of attorney? You know, it cleared our legal department, or are you just going in and handing that over to somebody that maybe isn't there 2 years from now?
Every bank and financial institution has its own policies and procedures. So one shoe doesn't fit all. What they typically do, will put it in their system. And their legal department has a checklist that they go through and check things off. Are they there? That checklist and the copy of the power of attorney normally stay within the system. So unless their policies change, you know, Diana was talking about needing an original versus a copy. Some banks require the original. It's not required by law, but it's required by their policy. Sometimes we use affidavits when we can't find the original. So, long story made short, can't solve all the problems, but generally speaking, if they put it in their system and they do their checklist, you're in pretty good shape.
Next question.
So if you don't have a beneficiary deed, but everything else is transferred on death,
if you split your asset, everything that you have between, say I have 2 kids and I want to split everything on that beneficiary deed, and I don't have a beneficiary deed yet, do I have to go ahead and get a will or a trust? Do I need that? Or can I just do a beneficiary deed, put both of them on there, and then?
So I have had some people come in and they do the beneficiary deed only. That's actually one of the more common things that a lot of people come in and do. And they've done, beneficiary designations on everything else, and that is fine. I still like people to get wills, and I'll give you a couple of examples. One is, let's say, after you pass away, one of the things that your heirs are going to do at some point is file a tax return for you. If you are getting a tax refund check from the IRS, that is going to be in the name of the deceased person. That is going to have to go through probate. A will is going to make that a little bit easier. And depending on how large that check is, could depend on how long that's going to take. But it's much easier with a will. The other example I will give you is I had a conversation with an insurance agent here recently. And he told me that he had some clients of his that died in a house fire. House completely burned down. The insurance company, because there was homeowners insurance, needed to write a check, a very substantial check for that house. There was no one on that house other than the owner that passed away. So that check ends up getting written to the estate. Now, having a will in place is going to make it a little bit easier, a little more cost effective to get that through probate. So, long and the short of it is, there are scenarios where I still think having a will, the stuff I forgot about, things that I wasn't anticipating coming in, and then, obviously horrific events that nobody can plan for, it's good to have a will because it will make the process easier for your family.
And in our family, it was really important to know who was the last person told that got the butter churn. Just saying. So even though you might have all your ducks in a row, there's still household items and things that you may want family members specifically to have. And the fight, I've been the executor a few times, and then I got a few more coming. So the fight goes on.
One other question I have, Joe, because I'm a numbers person. Everyone always asks me, what's my house worth? They go to Zillow. I can go online and look. What's it cost me, roughly, for a will? And I know it depends on each scenario, but how would you describe to people the cost? And then second question is, can you help someone that, for example, I have an uncle in Minnesota. Can you help my uncle put this together, or do I need to find an attorney in Minnesota?
So to your second question, it would probably be best for them to have an attorney up in Minnesota handle that, just because when they pass away, you've got to go to the state and the county where the person passed away to handle any affairs in probate court. So it's good to have a will from that particular state. And then as far as doing a will, like a very basic will, is just probably going to cost you several $100. It's not like
It's not 5,000, 10,000?
Good grief. I mean, that better be the best will that's ever been read. That's an expensive will.
So you said a couple $100.
Yeah, a few $100.
Okay.
So it may be.
Best money people can spend.
Yes.
Hi. Melissa, there's another question over there.
Right here?
This is my first familiarity with beneficiary deed. My husband and I were recently talking about our house, and we verified we did not have that in TOD, and that's what we were going to do. But that would not be the thing to do. We need to do the beneficiary deed. Is that correct?
You can answer that one. I don't have it.
Short answer is beneficiary deed, absolutely. That is absolutely what you need to do. And just to kind of reemphasize this point, houses are one of the most common things that go through probate because people forget to get the beneficiary deed. And they're also one of your most valuable assets, and they also take the longest to deal with in probate. And you all probably had examples of this. The worst case scenario is you have a house and there was no will, so every single time you have to get ready to sell a home, you all probably have to deal with this, it's a long process. You've got to file some paperwork to just get permission to take charge of the home, which you think, what, I'm family. No, you've got to go through court to do that. Then you've got to go to court to get permission to sell. Then you've got to get the court to okay the sale. Then you can actually sell, and then you've got to give a report to the court afterwards that you did sell. It's a lot of paperwork and multiple months.
So, I might elaborate some. I have 5 children. My wife and I have properties. Each of my kids are married. We could use a beneficiary deed to give our properties to our children. And in my case, that means 5 kids plus 5 in-laws would have to agree and sign everything, show up at the closing. It could happen, but it's a formula for bad stuff. Beneficiary deeds work, but they're sometimes, because of the circumstances, they're not the best vehicle. You know, the concept of not putting properties into a trust until you die, I think that works pretty well while you're young. But as you get older, if you've got property that should not be liquidated quickly or requires for a bunch of conflicting, arguing kids to agree on the sale, beneficiary deed can be a mess. Because they've got to come to an agreement on realtor and the price and conditions. So just remember, beneficiary deeds, I think, work really well for about 65% of the American population. But if you've got any conflict, dementia, Alzheimer's, beneficiary deed does not do well.
So the alternative to a beneficiary deed in some cases is?
It's either a trust, or you have a will that you're going to use as a trust to make the court sell the property. Will's a lot less expensive. But my point is, you can't say a beneficiary deed is the best and only way to transfer it into the trust or to your kids when you die. There's so many circumstances that would make a beneficiary deed a terrible way to do it. It would work, but it would be a real pain in the butt on the back end.
And just to clarify in my mind, a beneficiary deed is only for real estate.
There's beneficiary deeds for personal property.
Oh.
There's beneficiary deeds for real estate. In Kansas, they're called transfer on death. But what we're talking about is, what do you have to take to the recorder of deeds office?
Thanks for clarifying.
Another question?
So how do you get the beneficiary deed? Does the attorney do it at the same time they draw up the will, or do you have to go to a title company to do that? How do you get started on that?
So beneficiary deeds typically are drafted by an attorney. And you can get those done at the same time that you're getting a will, other estate planning documents like a durable power of attorney, healthcare directive. At least we do it, and I think probably most other offices do it. It's kind of all part of your estate planning package.
A lot of folks will
And then
say, Diana,
I will add something about the beneficiary deed. We make sure it does get recorded because if the person is deceased, it is no longer valid.
Say that again.
Make sure the beneficiary deed is actually recorded into the public record, because we've had people that thought that it was going to transfer, but it was never recorded into the public record. So if the person has died, the people that actually own the property, they're both deceased, that beneficiary deed is null and void because it needs to be recorded to the public record prior to death. And I want to say there's like certain days in Missouri, is it 48 hours possibly or 72 before someone can die? Like there's like requirements for it.
So I know that title companies can record it.
We do.
Attorneys, like, do you guys record it? What do you do once you get it back? You record it with the county.
Yep.
So
If
if
you
you're
don't-
doing a statement, are you taking care of that for me too, Joe? Okay, just making sure.
And there's people that will go to the recorder of deeds asking for that document. They're like, oh, here's a blank one, just fill it out. Don't do that. If your legal description is not correct, or if your name doesn't match how you're currently entitled, it's going to nullify the deed, and you thought you did everything the correct way, but you didn't. We are very irritated with the recorder of deeds that just to fill it out yourself. Don't do it. Just because you're going to save like a couple $100, you're not going to save that, or your heirs aren't going to save that money. They're going to pay a lot of money out.
for your kids, when they buy a home, I would recommend you close and then have the title company do the beneficiary deed that same day.
We'll report after.
And then they close, and then they record it, easy peasy, simple stuff. What typically happens, the problems happen is because you bought the house 30, 40 years ago, you never even thought about it because you were 25, 30 years old. So when I had some big projects, I just give them to the title company to do it, and then I look at their work. They're less expensive, faster, better for the client.
All right, next question.
Hi, first I want to thank Audra for putting this together. Thank you. And thanks for the people on the panel. A couple questions. One is, we've owned our house so long, I don't know, how do we find out what kind of deed we have? Because we were so young. Okay. And then my second one is, we've talked about wills and trust. Is there something that tips the scale that says you should have a trust rather than a will?
Do you want me to take a shot at this and then?
Please.
Okay. Then you can focus. I'll probably miss something. So there's a lot of things that go into consideration. One is, do you own property in multiple states? Because that property would be subjected to multiple state probate. Another thing is, do you have assets to where you don't want your kids or whoever to get all those assets at once? Do you have a blended family? Do you have a child that has a drug addiction or some other special circumstance? Do you have a special needs child? Trying to think. Those are right off the top of my head. So I'm like thinking, can you think of any others?
No, I mean, I think you did a great job. It's the complexity, not just only properties in multiple states, but what are your properties? And how many heirs do you have? Because I like a trust because it's a funnel with usually one person doing all the work, handing out all the checks, or do I want a committee, which is what the beneficiaries required? Let's all gather at Mom's house, all 5 or 6 of us, and we'll make a decision. I like the funnel, one person doing all the work, simple, easy, less expensive. But a will is only good in probate, and so you don't want to use a will as your primary distributing arm. You really don't. You're going to use the beneficiary designations. The will's just, as I've said, the parachute. Now, I'll tell you a secret. I have what I call the poor man's estate plan. Poor man's estate plan are the F4, the powers of attorney, plus beneficiary deeds. If they've got a special needs child, I'll add a will and put a special needs trust in the will so that the probate court can administer it. It's less expensive. The court appoints the trustee. It's expensive on the back end, but it's cheap on the front end. So there's many varieties of the question or the response to your question, but as Joe started out, it depends on the circumstances.
So do you have like a booklet or something that people fill out before they come to see you to help narrow it down, so since your time is costly, that it makes it cheaper? Or how does it work? Do you get this information?
I think all of us have forms or questions, we call them workbooks or questionnaires. There's the ones you do before we talk to them. And what we're trying to do with that is identify the problem. People don't come see Joe and I because it's a good day on the beach. Usually there's a trigger, some reason. I want to know the reason you're coming in the door. What's the pain? How can I solve it? And if I can do that, that really helps expedite the matter. So, yeah, we do. And then everybody has questionnaires or workbooks to help us draft whatever stuff they need or want.
Excellent. Next question.
In the case of power of attorney, okay, right here, okay. In the case of power of attorney, does it have to be recorded for, I had my sister's power of attorney, but as soon as she died, it was void.
Void on death.
So then it did no good at all, and I had to wait to be appointed the personal representative.
In terms of how many people think that a power of attorney goes past death, if the person's dead, they can no longer give, the power.
For some reason, we anticipate that the power of attorney will substitute for a will. And as Diana said, it terminates when you draw your last breath. But they're really good. And I think in the old-timey attorneys, and I'm one of those, we used to file, record the durable powers of attorney. I don't do that anymore. Because frankly, I don't want anybody to know my business. But what do they do with that? Do you recommend they file whether legal?
Depends on if they're organized or not, because for us, we have to have the original. And when it's recorded, we necessarily don't have to file against the legal description. It could just be recorded against the names.
So even if the power of attorney is recorded, you still would not accept that?
No, if it's recorded to public record, then we're good. Then we'll find that in public record.
Remember, some of the doctors want that power of attorney when mom's in surgery and we need to make a decision for her. It's before they die.
If I'm a resident of Missouri and I did my will and power of attorney and all of the things that you all talked about, and a beneficiary deed, but my property is out of state, and you said about recording it, but the property I own is not in Missouri.
So your property is outside of the state of Missouri,
Correct.
and you did a beneficiary deed though.
I have not yet. That's what I'm asking. Yeah.
So typically you would probably want an attorney in that state to do that beneficiary deed, because as you heard us talking up here, even the name of it is different state to state, just Missouri and Kansas. So you've got a transfer of death deed over in Kansas and a beneficiary deed over here. Are they essentially the same things? Yes, but there's going to be specific language in each state. Statutes are different in each state, so you want to get someone in that state to do that.
Okay, I have one other question, if you don't mind. What if the person that you want to be your executor or your trust actually does not live in this country? In this country.
It's interesting.
But not hard. As far as getting signatures, we can remote online notarization in the title industry. That's not working the courts.
So I haven't had that situation come up yet. I will tell you that we've had personal representatives out of state, and that's been fine because there's so much that can be done electronically. Now, the notarization part gets a little tricky because there's a few documents that you have to notarize. And I'm not sure how we would do that.
It kind of depends. When it really geeky right here. Certain countries are part of what's called the Hague Convention. And with the Hague Convention, what happens is that they're part of the convention where we all kind of recognize each other's notaries, but you have to do what's called an apostille. And the apostille will get attached to that notary, and then it's going to be valid over here. If that country is not part of the Hague Convention, you have to go to the U.S. Embassy. And rumor has it, be very pricey going to the embassy, and it can take weeks and months to get an appointment. During COVID, it took people 6 months sometimes to get to the embassy. Thank you.
Another question? Anyone?
I had a follow-up to kind of what she was talking about, is the criteria between a trust and beneficiary deeds or will decision. Is there a net worth factor amount of assets that might come into that decision? And also, if things are inside a trust, is there any sort of possible legal protection from someone coming after those assets since it's a separate entity?
I'll start with your last question. Is there any protection with the use of a trust? The two most common trusts is a revocable living trust. Absolutely no asset protection, which is it is the most common. It's about control. Very common. Uses your social security number normally. You're the trustee. No protection. There is what's called an asset protection trust generically. It is technically called an intentionally defective grantor trust, an IDGT. You can look it up. We do lots of those, and those protect assets from creditors. There are no tax consequences, so they're pretty cool. We do them for ranches, farms, homes, businesses, rentals. And that's where the 5-year look back applies. So if you want one, you need to get it before you're knee deep in bad stuff. But it's pretty cool. Now the second question was, what was that? Yeah, I think on probate, the reason you might want a will, probate, if it's what is going to be probated is less than $15,000 or less, it's a small estate. You trip over to the probate office and you file an affidavit and you're done. If it's less than $40,000, you fill out the same affidavit, but they do one publication, and then you're done. So those are pretty easy. Most problems that do arise are less than $40,000. Usually it's like the coupons that you get from the co-op or the tax return. It's $1,000 to $2,000, or the $2,000 car that you didn't put the TOD on. It's usually something. The downside is they won't let you do it without getting an attorney. So that's the only place I'm aware of on threshold for assets.
So he was thinking maybe if I have under 400,000, I don't need a trust, but if I have over $1 million, I do. That's the question, I think.
The answer to that's no. No, I mean, it has, folks, for me, it has almost zero as to how much money you got. People will come in and they will refuse to tell me what their assets are because they think I'm going to surcharge them because they got money. That's silly. It has to do with the circumstances. What are the needs? What are the wants? What are the problems? That's going to determine whether you need a trust or not. I've had financial advisors send me clients that have a few $1 million for a trust. They got one kid, and it's a good kid. They got a bunch of accounts. I looked at them and said, I don't think you need a trust. I'll do it, but I don't think you need one. The difference between need and want. Some people get a trust because all their friends have it.
Other questions? Well, thank you for coming. We are going to have our panelists, they have tables to sit so you can have some one-on-one conversations in case you have questions that you didn't want to ask outright. And some of our other community partners are here as well to talk with you. And we look forward to seeing you for our next one next month. Thank you.